Imagine being handed a $12,000 speeding ticket for a car you weren't even driving.
Oh, that sounds like a nightmare.
Right. I mean, you weren't in the vehicle, you don't hold the keys, and you have absolutely no control over the person behind the wheel.
You're just totally uninvolved.
Exactly.
Yeah.
Yet the federal government insists you pay up simply because you helped finance the gas. And in 2027, that is exactly what the federal government might do to a real estate broker here in Colorado.
It's wild that looming threat of massive federal liability is really just driving a wedge right through the middle of how real estate transactions actually happen on the ground. We're watching these abstract federal regulations violently collide with daily practice.
Welcome to our discussion. It's as of July of 2026, and the proposed forms and contract changes are now available to review. We attended the stakeholder meetings hosted by the Division of Real Estate, and we are using our notes from those meetings, along with the newly available Redline forms, to take a final look at what changes might be coming to the Colorado contracts and forms for 2027.
And we should establish up front, that this is all still entirely speculative. The commission, which is the body that approves the final forms and contract changes, they won't actually see these until at least the August 4th meeting.
Right.
And perhaps some forms may even carry over to the October commission meeting. But we do think we have a pretty good idea right now of what is coming down the pipeline.
Yeah, rather than getting lost in the weeds of, like, every single typo fix or formatting adjustment, we're going to synthesize the key changes. Our mission today is to dig into the underlying mechanisms of these changes and highlight the specific areas that generated the most heated debate during those stakeholder meetings.
So you're fully informed on what to watch for.
Exactly. We want you ready for August 4th. Let's start with those rules trickling down from the federal government that are fundamentally altering local responsibilities. Specifically, the lead-based paint disclosures.
Right, so the Division of Real Estate, or DRE, is updating these disclosures to mirror the new Environmental Protection Agency forms. And the mechanism causing so much anxiety here involves how the EPA actually defines the word agent.
Oh, this was a mess.
It really was, because the federal government defines agency based entirely on the flow of payment.
Okay, let's unpack this because this caused an absolute uproar in the meetings. In a typical real estate transaction, a buyer's agent is often paid via a cooperative agreement by the seller, right?
Correct.
The seller takes a portion of their proceeds and uses it to compensate the person who brought the buyer to the table. Under the EPA's logic, because the seller's money is flowing to the buyer's agent, that buyer's agent is now legally considered an agent of the seller for the specific purpose of the lead-based paint disclosure.
What's fascinating here is how this redefines liability by completely ignoring the legal firewall that exists between a buyer's agent and a seller.
Yeah.
I mean, the EPA doesn't care about state-level fiduciary duties. They care about enforcing the Residential Lead-Based Paint Hazard Reduction Act. They look at the cooperative compensation and declare that if you take the seller's money, well, you are responsible for ensuring the seller complies with federal law.
Which brings us back to that speeding ticket analogy. How is a buyer's agent supposed to force a seller they have absolutely no contact with to comply?
They really can.
Right. During the stakeholder meetings, brokers like Eric and Tammy were incredibly vocal about this disconnect. Tammy pointed out that listing agents notoriously forget to send the required EPA pamphlet to the buyer's side.
Oh, all the time.
She testified that she sees it come over maybe 10% of the time. You end up with buyer's agents held hostage, completely unable to fulfill a federal mandate because the listing agent on the other side of the transaction just drops the ball.
And the penalty for that dropped ball is severe. The EPA issues fines of $10,000 to $12,000 per violation. So the DRE is dealing with a terrified broker population right now.
Yeah, Eric pointed out that our state contracts previously evolved specifically to protect buyers from this very issue. The old forms allowed a buyer to wait until they actually received the lead-based paint disclosure to be bound by the contract.
But now the federal rule demands compliance before an offer is even accepted.
We are essentially going backwards, technologically and procedurally, just to appease this payment flow technicality.
The DRE's ultimate priority with these form changes is harm reduction for the licensee. They are listening to these complaints from people like Eric and Tammy, but, well, the state cannot override federal law.
They're stuck.
They are. The underlying philosophy is that the division cannot set brokers up for federal failure. The state forms must mirror the federal requirement so that a broker using a Colorado-approved form isn't accidentally walking into a massive EPA trap.
Protecting the bank account.
Exactly.
Hmm.
The forms are adapting to protect the broker's license and bank account, even if it creates an absolute logistical nightmare on the ground.
So that fear of federal liability trickles down perfectly into our next area of focus. Because the state is just as anxious about legal boundaries as the federal government. The paperwork is fundamentally shifting to address state laws regarding legal practice and fiduciary duty, and it starts with confidentiality.
Right. The DRE is actively stripping the blanket waiver of confidentiality out of several forms, including the short sale addendum and the brokerage duties to tenant disclosures.
Which is a big change because for years, there has just been this simple one-sentence checkbox in these forms stating the client waives their right to confidentiality.
Yeah, but the division is removing it because they're arguing that a one-sentence waiver simply does not meet the legal mechanism for informed consent.
Right.
Informed consent requires the client to fully comprehend the specific risks, implications, and alternatives of waiving a legal right. A simple checkbox fails that legal test miserably. Courts generally look poorly upon consumers signing away core protections without evidence of a substantive discussion.
So brokers are going to have to actually talk to them.
Yes. Brokers are now going to be required to have actual, candid conversations about the risks of sharing confidential information, rather than just pointing to a dotted line and saying, sign here.
A stakeholder named Hans, who is an employing broker with 25 years of experience, he pushed back hard on this during the meetings. He argued that taking that bold, written paragraph out of the agreement actually harms the process.
Oh, so?
Well, he asked if removing a written prompt actually protects the consumer, or does it just create messy verbal disputes down the road? Hans argued that without that text right in front of their face, the conversation might just be forgotten entirely. Or worse, the client later goes to court and claims they were never told.
Hans is really highlighting a classic friction point between legal theory and daily practice. The DRE's stance, backed by their legal counsel, is that a consumer signing a dense contract often completely misses a one-line waiver anyway, rendering the signature legally useless.
So they want them talking.
Exactly. The state wants brokers communicating. However, the legal requirement for informed consent itself is currently in jeopardy.
Because of the Sunset Bill. Let's explain how that Sunset Bill actually functions in this context.
Sure. A sunset bill is basically a legislative review process that evaluates whether a specific state regulation should continue to exist. And the Colorado Association of Realtors introduced a sunset bill that proposes stripping the informed consent requirement from the statute entirely.
Reverting it back.
Yes, reverting the legal standard to just express written consent.
Meaning, by the time these 2027 forms actually roll out, the legislature might have changed the law back, and that one-sentence waiver might be perfectly legal again.
We simply have to impartially watch how the legislature votes on this, but it perfectly illustrates the tension driving these form changes. Brokers want streamlined, prompted paperwork to protect themselves from verbal disputes, but the state is constantly guarding against consumers signing away their rights blindly.
And this same guarding mechanism applies to the unauthorized practice of law, right? Specifically with the title-related objection notice.
Yes. The proposed updates add bold text explicitly stating that the broker is merely a scrivener who cannot provide legal advice. The Commission is also floating a brand new concept, a title resolution form.
Stakeholders like Jeff Anderson, an attorney, were blunt about why this bold text is necessary. He stated there is absolutely no way a real estate broker can evaluate a title commitment, decipher the legal implications of an easement or a covenant, and advise a client without practicing law.
He's not wrong. The moment you start interpreting how a title defect impacts property rights, you are acting as an attorney.
But on the flip side, you have brokers in rural and resort areas like John from the Western Slope saying they deal with minor survey issues and boundary line adjustments every single day.
Oh, for sure.
If a rural broker has to hire a lawyer every time a fence is 3 inches over the property line, the transaction is just going to grind to a halt.
The DRE is trying to draw a hard boundary here, defining exactly what a broker can safely negotiate within the limits of their license. The scrivener text acts as a legal firewall. It tells the consumer the broker is simply transcribing the objection, not analyzing its legal merit.
So what does this all mean? The paperwork is forcing a very hard boundary between being a helpful real estate agent and being an unlicensed attorney. And that shift from abstract legal boundaries takes us directly into the physical, messy realities of a home actually changing hands.
because this is where the law meets the delayed delivery truck.
Exactly. Let's talk about the inspection resolution form.
The scenario discussed in the stakeholder meetings is incredibly common. A seller agrees to fix something before closing, like replacing a broken window. But the glass company has a supply chain issue or the installer gets a flat tire.
Things happen.
Right. These are circumstances totally out of the seller's control.
A broker named Liz asked if the forms could include an extension or a grace period for the seller in these exact scenarios. Currently, if that window isn't fixed by the exact date on the contract, the seller is automatically in default.
Yep.
Here's where it gets really interesting. If you hire a plumber to fix your sink and he gets a flat tire, you don't instantly sue him for breach of contract. You give him an hour. So why should a seller instantly be in default, risking the entire sale of their home just because a window truck didn't arrive?
Well, it's an appealing argument, but a broken window on a house isn't a flat tire on a plumber's van. It is a physical security vulnerability on a $500,000 asset that the buyer is about to take ownership of.
That's true.
Stakeholder John pushed back on the grace period idea heavily, because if you give a seller an automatic built-in grace period for delays, the buyer takes on the entire burden of that risk. The buyer is left unprotected, potentially having to close on a house that still has a shattered window, relying purely on a broken promise.
Yeah, John argued that if a seller cannot perform, they should be in default, precisely because it forces the parties to negotiate an actual written amendment.
It forces communication.
Exactly. Instead of getting a free pass to drag things out, the seller has to go to the buyer and say, hey, I can't fix the window today. Will you accept a financial credit at closing instead?
Defaulting forces a legal resolution rather than leaving the buyer in limbo. The forms must prioritize protecting the party taking on the physical and financial risk of the property. And we see that exact same philosophy applied to the post-closing occupancy agreement, or the PCOA.
Right. A PCOA is used when a seller needs to rent the house back from the buyer for a short period after closing. And Senate Bill 26-054 was signed into law in April and takes effect January 1st, 2027. Because of this new law, the DRE is removing the restriction in the PCOA form that previously capped security deposits at 2 months' rent.
If we connect this to the bigger picture, it's really about adjusting the contract to match the actuarial risk of the property rather than treating it like a standard apartment lease.
Makes sense.
In a post-closing occupancy, the buyer legally owns the home, but the previous owner is still living in it. The physical risk to the new buyer is astronomical.
Stakeholder Gordon pointed out a massive flaw in the old system. The rent charged for a 3-day post-closing occupancy might only be a nominal amount, say, I don't know, $1, just to establish legal consideration in the contract.
Right.
Under the old rules, capping the security deposit based on that nominal rent left the new buyer entirely exposed. If the seller accidentally floods the kitchen while moving their washing machine on day 2, a $2 security deposit doesn't cover a $20,000 remediation bill.
Exactly. The new law recognizes that a PCOA requires a meaningful security deposit to protect a massive physical asset. It decouples that deposit from the rent amount entirely, acknowledging that the person holding the title holds the risk, and they need the ability to demand adequate protection.
So once the physical closing logistics and the move-in risks are handled, the focus of the new forms shifts to the long-term realities of living in the home.
The stuff buyers really worry about later.
Yeah. The forms are being modernized to reflect what buyers actually care about, starting with the green energy disclosure. This form hasn't been updated since 2012.
It was way overdue. The division worked closely with the Colorado Energy Office to update the certifications and performance metrics, allowing sellers to effectively market modern green features based on current building science.
But there is a massive new disclaimer being added to this form. It explicitly states that disclosing the presence of an item is not a warranty of its operability.
This shifts the burden of verification squarely onto the buyer. I mean, checking a box for solar panels just means the hardware exists on the roof.
Right.
It does not guarantee they are connected to the grid or that the inverter functions or that they are actively generating electricity. The buyer must now proactively hire a specialized inspector to verify the mechanics themselves.
That burden shift is significant, but honestly, it pales in comparison to the brand new HOA disclosure draft.
Oh boy, yes it does.
This is a highly anticipated, entirely new form designed specifically to warn buyers about the harsh realities of homeowners associations. I have to ask why. Buyers already receive a mountain of HOA documents during the transaction. The covenants, the bylaws, the financials. Why do we need an entirely new warning form on top of all that?
We heard incredibly powerful testimony from Connie, an 8-year HOA homeowner advocate. She pointed out that buyers treat the HOA as an afterthought, simply the group that keeps the community pool clean and dictates fence colors.
Right, just a neighborhood watch on steroids.
But the reality is that an HOA is a mandatory legal and financial structure with extreme enforcement mechanisms.
Connie explained that HOA disputes are strictly court-enforced, and homeowners have spent hundreds of thousands of dollars fighting them. She actually cited one case where a homeowner spent over $1 million in legal battles with their association.
It's terrifying. Let's look at the mechanism of how an HOA can enforce such astronomical costs. HOAs in Colorado possess what is known as a super lien priority for unpaid assessments.
It's super lean.
Yes. If a homeowner falls behind on dues or racks up fines for covenant violations, like painting their house the wrong color, the HOA can place a lien on the property. Furthermore, they can initiate a judicial foreclosure to collect that debt.
Wow.
The homeowner isn't just facing a bad credit score, they're facing the forced sale of their home by a private corporation just to settle dispute fees.
That changes the perspective entirely. It's not just a fine for leaving your trash can out. It's a mechanism that can quite literally take your house away.
The DRE recognized that consumers deserve to understand that specific legal mechanism before they buy into a mandatory HOA structure. This new form strips away the dense legal jargon found buried on page 40 of the covenants.
Plain English.
Exactly. It uses blunt, plain language. It explicitly warns buyers that HOAs are privately run, that assessments can skyrocket, that massive special assessments for community repairs are real, and crucially, that they can be foreclosed upon for unpaid debts.
So to wrap up our discussion for today, we've covered a lot of ground. From the federal panic over lead-based paint liability and payment flows, to the state-level battles over confidentiality and legal boundaries.
And right down to delayed window installations and the judicial foreclosure mechanisms of an HOA.
It is a comprehensive overhaul aimed at forcing awareness and keeping pace with a rapidly changing regulatory environment. As a reminder to you listening, we will all be watching that August 4th Commission meeting closely. That is when we will see which of these passionate stakeholder debates actually turn into finalized ink for the 2027 forms.
And this raises an important question, one that connects all of these themes. We are watching these real estate contracts grow longer and longer. They are ballooning to include every possible legal warning.
Oh, absolutely.
From federal lead laws to plain language HOA foreclosure warnings to explicit disclaimers about broken solar panels.
So, what does this all mean? Does the sheer volume of these protective disclosures actually result in consumers suffering from massive information overload? Are we reaching a point where buyers are so overwhelmed by the hundreds of pages of warnings that they just stop reading entirely?
Have we reached a tipping point where more paperwork actually equals less actual protection?
Yeah.
When a contract becomes so dense with warnings, fine print, and overlapping jurisdictions that you can't even see the core transaction anymore, you have to wonder if it is actually keeping anyone safe at all. It's something for you to mull over until the commission makes their final call.
Definitely. Thanks for joining us for this discussion into the 2027 forms. We'll be watching August 4th, and we'll see you next time.